Hello, my name is Georg Haindl and I'm a law student at the University of Vienna.
Hello everyone, my name is Evelin Kele and I'm also a law student at the University of Vienna. Today we are going to present the case C-410/19 of the European Court of Justice. This case is about the liability of online content sharing service providers. So we have chosen this case not just because we believe it's going to be very interesting for all of you who are watching us right now, but it's also quite relevant to this course. There are some basic facts you need to know about this case. As I've already mentioned, the parties are the Republic of Poland and the European Parliament and the Council of the European Union. The action was brought on the 24th May 2019 because the Republic of Poland claims infringement against Article 11 of the Charter of Fundamental Rights and that the court should annul Article 17 Paragraph 4 Section B and Article 17 Paragraph 4 Section C of the Digital Single Market Copyright Directive and amending directives. Article 11 of the Charter of Fundamental Rights guarantees the freedom of expression and information. It includes the freedom to hold opinions and to receive and impart information and ideas. It is a key component of our democracy because the promotion of participatory decision-making processes by individuals is just unattainable without an adequate access to information. The main argument of the Republic of Poland is that Article 17, Paragraph 4 of the Digital Single Market Copyright Directive requires a prior filtering of content. Article 17, Paragraph 4 makes it necessary for the service providers to carry out a prior automatic verification of content uploaded by its users. It means that the introduction of preventive control mechanisms is required. According to the Republic of Poland, such mechanisms are not compatible with Article 11 of the Charter of Fundamental Rights because such mechanisms undermine the essence of the right to freedom of expression and information, and they also do not comply with the principles of proportionality and necessity. Article 17 of the Digital Single Market Copyright Directive provides the liability of online content sharing service providers in case of unauthorized communication to public of copyright protected works and other subject matter. If they want to avoid liability, they have to make best efforts to get authorization according to point A. They also have to make best efforts to ensure the unavailability of specific works and other subject matter for which the right holders have provided them the relevant and necessary information. And in any event, they have to make best efforts to undertake a takedown and stay down of notified content. It means Article 17 is not just about removing content, but it is also about preventing future uploads. For this reason, the Republic of Poland claims that Article 17, Paragraph 4 is not compatible with Article 11 of the Charter of Fundamental Rights.
Let's have a closer look on the opinion of Advocate General Henrik Saltmansgaard. The Advocate General stated that Article 17, Paragraph 4 of the Digital Single Markets Directive do interfere with the user's rights to freedom of expression and information, because service providers must take monitoring measures to be able to take advantage of the exemption of liability. The freedom of expression and information, as mentioned before, is regulated by Article 11 of the European Charter of Fundamental Rights. The Advocate General deems that Article 17 of the DSM Copyright Directive is compatible with the requirements of the Article 52, paragraph 1 of the CFR. According to Article 52, limitations on freedoms are permissible if these limitations are provided for by the law, respect the essence of each freedom, and respect the principle of proportionality, which means that the essence, especially of freedom of expression, is kept. In principle, any preventive control of information constitutes an infringement of the right to freedom of expression. However, the essence of freedom of expression would only be affected if service provider were obliged to preventively monitor and search their users' content for illegal use of copyrighted material. Furthermore, the Advocate General mentioned that also the principle of proportionality is given. The regulation serves to protect the intellectual property guaranteed in Article 17, paragraph 2, and does not go beyond what is necessary to achieve this objective. In the case of the DSM Copyright Directive, the European Union legislator has decided in favor of the right holders and redefined the exemption from liability for providers of online sharing services. This was previously regulated in the so-called e-commerce directive from the year 2000. Through the Article 17, the liability is newly regulated. One of the major dangers is the much discussed overblocking, and is also mentioned by the Advocate General in his opinion. Service providers could block users' content at the slightest doubt to exclude any liability, even if the content is allowed to be uploaded within the scope of the applicable copyright law. Additionally, the Advocate General states that in most cases service providers are actually forced to use upload filters if they want to meet the requirements of Article 17, paragraph 4. Advocate General Sorgmannsgaard notes that protective measures have been taken to minimize the risk of overblocking. According to Article 17, paragraph 7, service providers are not allowed to block every content preventively. Furthermore, Article 17, paragraph 8 requires service providers must only identify content that is manifestly illegal. In controversial situations, it is not the service providers who should decide on copyright issues, as they do not have the necessary expertise and, above all, the necessary independence. In the opinion of Advocate General, these measures are sufficient to minimize the risk of overblocking. Therefore, he pleads to dismiss the case. As of today, for this case, there's just the opinion of the Advocate General, which was stated in July 2021. This means that the opinion is a non-binding proposal for the Court of Justice of the European Union. The Court of Justice is not obligated to the Advocate General's opinion, but in most cases it does agree with the reasoning of the Advocate General. By end of September 2021, only 4 member states of the European Union implemented the Digital Single Markets Directive in their national law. The Commission has announced that it had opened infringement proceedings against 23 member states which did not implement the DSM directive. For this presentation, we use these following sources. Thank you for watching this video presentation.
Thank you for watching.